Hello, everyone, and welcome to One Civil Law, where we learn through the misfortunes of others. If you're enjoying our legal education content, please remember to subscribe. It helps the channel to grow. For our first case in a 3 series of cases, we are going to deal with Griswold versus Connecticut. This is a case from the United States Supreme Court from 1965, which deals with the right of married people to use contraception, which was illegal in the state of Connecticut in 1965. Married people could not use contraception in Connecticut in 1965. So we're going to review this case as part of a 3-part series relating to the topic of, some topics that are important related to procreation. So let's get started with this. The appellant Griswold is the executive director of Planned Parenthood League of Connecticut. The appellant Buxton is a licensed physician and professor at Yale Medical School who served as medical director for the league at its center in New Haven, a center opened and operated from November the 1st until November the 10th of 1961, when the appellants were arrested for what they did. What did they do? They gave information, instruction, and medical advice to married persons as to the means of preventing contraception. So they taught married people how not to have kids. That's what they did. They examined the wife and prescribed the best contraceptive device or material for that use. Fees were usually charged, although some couples were serviced for free. The statutes whose constitutionally were involved in this appeal are the relevant laws of Connecticut at the time in 1965. These laws provide the following terms. Any person who uses any drug, medicinal article, or instrument for the purpose of preventing contraception shall be fined not less than $50 or imprisoned not less than 60 days, nor more than 1 year, or be both fined and imprisoned. And any person who assists, abets, counsels, causes, hires, or commands another person to commit any offense may be prosecuted as if they were the offender. The appellants were found guilty as accessories and fined $100. So, yeah, in Connecticut in 1965, it was illegal for any person to use any drug or medical device or other means to prevent conception from occurring. Any person, including married people. And it was illegal for any person to aid or abet them, such as by teaching them or prescribing them medication. And yes, this went to condoms or any means of preventing conscription and applied to married couples. This is the law in Connecticut in 1965. This is Griswold. And so, yeah, this was, then the directors of Planned Parenthood, who were operating for 10 days until they got busted, the directors of Planned Parenthood said, you don't want to have kids. What if you tried this? And they got arrested and fined $100. So we're going to find out whether or not they can get arrested and fined $100 for teaching married people how not to have kids. Let's read more. We think that these appellants have standing to raise these issues of the rights of married people with whom they have their professional relationship. So the people that are suing are the doctors, not the married couple. And the question is, can the doctors sue for what they did? Yeah, probably because they were arrested too. And this case is more akin to another case where an employee was permitted to assert the rights of their employer, to another case where owners of a private school were entitled to assert rights of pupils and to their parents, and to another case where a white defendant, partially due to a racial restrictive covenant, who was being sued for damages by covenanters because they conveyed their property to black people. So, yeah, this used to be a thing too. There used to be these things called restrictive covenants, which made it illegal for a person to sell their property to a black person. And someone was actually arrested and charged for selling their property voluntarily to a black person because, once again, restrictive covenant, because it was illegal. 1965. Okay, the rights of the husband and wife, while pressed here, are likely to be diluted or adversely affected unless those rights are considered. So even though the medical professionals are not the couple, they can at least argue whether or not the couple should be allowed to have conception or not. Because we allowed it in the case with the white person who might want to sell their land to a black person someday. So that might be okay. Maybe they can raise that issue. The Association of People is not mentioned in the Constitution nor the Bill of Rights, which is true on its own terms. The Constitution never explicitly mentions a freedom of association. It's sort of strongly implied in the First Amendment, but then again, doesn't actually use the term freedom of association, so true enough. So how has that played out in the past? In a prior case called Pierce versus Society of Sisters, the right to educate one's children as one chooses is made applicable to the state by the force of the 14th and 14th Amendments. So parents might be able to choose how their kids are educated. In a case called Meyer versus Nebraska, which I had forgotten was cited in this case, because wow, the same dignity is given to the right to study German language in a private school. You understand this? In Nebraska, it was illegal for a private school to teach the children the German language. You get this? In Nebraska, it was illegal in a private school to teach children how to speak German. That was Meyer versus Nebraska. Excellent. In other words, the state may not, consistent with the spirit of the First Amendment, contract the spectrum of available knowledge. The right of freedom of speech and press includes not only the right to utter or to print, but the right to distribute, the right to receive, the right to read, and freedom of inquiry, freedom of thought, and freedom to teach. Indeed, freedom of the entire university community. So, yeah, the First Amendment may not say explicitly that you have the right at a private school to teach German, but we think that might fall somewhere within freedom of speech. So that's Meyer versus Nebraska, which is coming up in a right to use contraception case. So the right to teach German apparently is related to contraception. Okay, well, there you go. Other cases have involved more than a right to assembly, a right that extends to all irrespective of race or ideology. The right of association, like the right to belief, is more than a right to attend a meeting. It includes the right to express one's attitudes or philosophy by membership in a group or affiliation with it by other lawful means. The foregoing cases suggest that specific guarantees in the Bill of Rights have, and this is where the conservatives get really, really grumpy right here, so pay attention. The specific guarantees have penumbras formed by emanations from those guarantees that help give them life and substance. Various guarantees create zones of privacy. The right of association contained in the penumbra of the First Amendment is one that we've seen. The Third Amendment, in its prohibition against the quartering of soldiers in any house in times of peace without consent of the owner, is another facet of privacy. The Fourth Amendment explicitly affirms the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. The Fifth Amendment, in its self-incrimination clauses, enables the citizen to create a zone of privacy which government may not force him to surrender or determination. The Ninth Amendment provides the enumeration of certain rights shall not be construed to deprive others retained by the people. Okay, so now we have to go into hardcore conservative, hardcore originalism, hardcore textualism mode. And we have to really discuss the full limits of originalism versus textualism. Now, before I do this, I'd like to point out that as of today, most conservatives, including myself for that matter, abide by precedent. So, if I were a judge, don't panic. I'm not going to overturn these cases because precedent is important and they've been on the books for like 100 years in some cases. But let's go back in time and ask ourselves whether they were correct in the first place. Because that's questions we can ask, right? Just as much as we can ask like a case versus Wickard v. Filburn, right? We've talked about Wickard v. Filburn. That's like 80 years old. And we talk about that case as a foundational case. We talk about slaughterhouse cases. That's late 19th century. We talk about those cases. So we can go back in time and we can discuss whether they were right in the first place, regardless of what we're going to do now. All right? So again, if we were going to do this today, even I, as a conservative, and pretty much every conservative on the face of the earth, values precedent as a valuable proposition. So let's go back in time and say, were they actually right in the first place? Were they rightly decided? Okay, so this goes into a lot of how do you interpret the First Amendment and not, and what are the scope of the First Amendment or not. So you could interpret the provisions of the First Amendment a lot of different ways, because this is a lot of First Amendment stuff. So you have freedom of speech, freedom of religion, freedom of assembly, freedom of petition, freedom of press. Those are your 5 First Amendment freedoms. Okay, so can we fold, for example, the right to teach German into that? Sure. I mean, that's freedom of speech, presumably, right? That's speech in German or speech in English. So we can probably get away with that in First Amendment without blinking an eye. How about freedom of association? Well, it doesn't really say association, but it does talk about right of assembly. And if you're assembling, I mean, that's kind of a group of people. And also, religion is a group of people. And a press can be a group of people. So maybe there's a freedom of assembly in there too, although we have to be concerned about that. So some of these ideas, yeah, maybe you can look at the text. But like a hardcore textualist, a hardcore originalist, especially if we're like a Justice Black. Justice Black was super hardcore. He'd say no. He'd say no to all this crap. That's how hardcore he was. And then again, he would say it's Justice Black was so hardcore that he would interpret the First Amendment very, very literally both ways. Justice Black was an interesting guy. He'd say Congress shall make no law concerning freedom of speech. He'd interpret that absolutely. So some of you guys may like Justice Black and some of you may not. He would say no law means actually no law. He despised things like standards of review. He despised any kind of exception. He said, nope, First Amendment says Congress shall make no law. That means absolutely no law of any kind, any description. Screw standards of review. Screw anything else. None means none, absolutely none. Now you guys might like half of that. However, he also took the other half you might not like. Because he said, well, what does it say? It says Congress shall make no law concerning freedom of what? Speech, right? So he wouldn't extend that to, for example, manner of dress. He wouldn't extend that to manners of expression. He wouldn't, in Tinker v. Del Monte, he wouldn't extend that, if he was alive at the time, he wouldn't extend that to the students wearing the Vietnam armband, the black armband, because that's not speech now, is it? No, it's not. It might be symbolic expression, but that's not speech. So Justice Black was an absolutist both ways about this. It's like, we'll give you absolute freedom of speech, but only speech and nothing more. So that's a Justice Black. That's how hardcore he was. So we could go down that road, or we could go down a whole lot of roads. But yeah, where the conservatives in general. So Justice Black is like the most extreme conservative known to man. He's like, there's no one more conservative than Justice Black. That's about as conservative as you can theoretically be. But yeah, if you don't go that hardcore, the conservatives still get really upset with like the idea of penumbras. Because like, what are penumbras and what are not? What are these shadows and illusions? And you start talking about rights of privacy. It's like, wait a second. Where's that come from? Well, it comes from an assembly. It comes from speech. And it's from the 4th, 9th Amendment. It's like, So, and now, like someone like a Justice Scalia would, of course, say that just means what's constitutionally permitted. So it doesn't prevent the legislature from extending more rights. So Justice Scalia, for example, I don't know what he thought about this particular case of Griswold from originalist perspectives, but assuming he disagreed with it, Justice Scalia would have said, well, a legislature could always extend you the right, so there's nothing preventing them from doing it, they just don't have to. So from first principles, one would think like a Justice Scalia wouldn't say Griswold is correct. Because there's nothing preventing, I mean, whatever freedom of speech might be. So, because we see how many derivatives were in here. We start with like freedom of speech, freedom of religion, freedom of assembly, from which we're going to, not even freedom of assembly, because that's not even there. So we have freedom of speech, freedom of religion, freedom of assembly is in there, from which we get a derivative principle, freedom of association, from which we're getting a derivative principle, right of privacy, from which we're getting a derivative principle, right of contraception. So like somewhere along the lines, the conservatives are not having any of it. If you're Justice Black, you failed at step 1. If you're Justice Scalia, you're somewhere along the line. And it's like, yeah, this isn't going to work because it's too derivative. It's like, where's it coming from? So, like a Justice Scalia conservative would say, presumably would say Griswold is wrong because the state can regulate the practice of medicine, which is fundamentally what we're doing. We're talking about the practice of medicine. So, yeah, it depends where on the conservative spectrum you are. But, if you're hardcore originalist, hardcore textualist, if you're hardcore originalist, hardcore textualist, can you really think that the First Amendment or any other provision of the Constitution really extended to contraception? That was really what they had in mind when they wrote the First Amendment? Probably not. So the conservatives get really, really grumpy when they see a word like penumbra. It's like, uh-oh. We're looking too far. So this is where the conservatives get off the train if they didn't get off before. So hopefully that was helpful. Justice Black was hardcore, man. Justice Black was hardcore. He was an originalist before Scalia was an originalist. Justice Black was a major influence on the conservatives. You know, we all say like how but for Justice Scalia, originalism wouldn't exist. You know, without Justice Black, it's not clear Justice Scalia exists. So like if we're looking for people before Justice Scalia, I mean, Justice Black was a major, major influence on the court. Major influence in the court. And Justice Scalia, and a lot of people think of him as like a major foundational court. Like a lot of conservatives won't go that far. I'm not even sure Justice Thomas will go that far. That's how hardcore Justice Black was. I'm not even sure Thomas goes that far. That's how hardcore Justice Black is back in the day. But yeah, like without Justice Black, I'm not even sure Scalia goes back. So that's where, you know, Justice Black is forgotten these days. But man, he was a hardcore pain in the ass. We deal with a right of privacy older than the Bill of Rights, older than our political parties, older than our school system. Marriage is a coming together, for better or worse, hopefully enduring, and intimate to the degree of being sacred. It is an association that promotes a way of life, not causes, a harmony in living, not political faces, a bilateral loyalty, not commercial or social projects, yet is an association for as noble a purpose as any involved in our prior decisions. Thus, that brings us to the end of the discussion of Griswold versus Connecticut, a case that rules that married couples have the right to receive education and relating to contraception, which may seem a bit of a ridiculous proposition today, but Connecticut wanted to make it illegal. Maybe Roman Catholic, whatever, but they did. And so, yeah, they sued, and yeah, the Supreme Court says, okay, here's what the Supreme Court says, and somewhere along the line, the conservatives get grumpy. So how conservative are you is basically where along the line you get grumpy. But somewhere along the lines, the conservatives get grumpy. So the first thing is, okay, the First Amendment, by freedom of religion, freedom of press, freedom of assembly, freedom of the freedom of religion, and the freedom of all those freedoms, it implies a freedom of association. And you're like, okay, maybe a freedom of association, which implies a right to privacy. It's like, where are you getting that from? Well, the First, Fourth, Third, Ninth Amendments, and you're like, okay, maybe a right to privacy, which implies a right to contraception. And the conservatives are like, wait a second, how are you getting that from the Constitution exactly? So somewhere along the line, the conservatives get grumpy. And they get very, very grumpy when you start talking about penumbras, because it's like, what are the limits of this thing? And yeah, this is the foundational case for Roe versus Wade, in case you couldn't figure it out. This is the case that basically lets Roe versus Wade come into being. And the conservatives are grumpy even with this, because it's like, it might be a good idea for married people to be able to have contraception, but where's the constitutional root in that? And it's a little bit hard to find. And then you get to Roe and you're like, oh yeah, no, this doesn't quite make sense. But that will have to wait for another day. But for the moment, my friend, thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. Until later, my friends, cheers and goodbye.